for forensics as to what that actually means. The another, in this case, was the homeowner, not CCM. And in the Marbles case, the another was the individuals that were utilizing these services. The artists were free to reject editions or assignments, and that's true in CCM as well. The client, the services were not for the benefit of the agency or the benefit of CCM.
Counsel, if we go down that road, the road that employer services would take us down, anytime any service provider, say a nurse, provides dialysis for a patient, she's not doing it for the hospital, she's doing it for the patient. So it seems to me that taking that route leads us in a sort of absurd situation.
Well, the actual cleaning services that are being provided were not cleaning services for CCM's building.
Right, but any service providing industry, that's going to be true, that the people providing the service will be providing them for a customer, not for their employer. And I'm not saying that whether it's an employment relationship or an independent contractor relationship, that's just always going to be true, that the services are being provided for the customer.
I agree, it is true, and it's true in all 5 of the other cases, that they were providing it for the individuals who are identified, for example, in Renomom. They're providing it, the service by the mom is being provided not to directly, but to Renomom, but to the clients of Renomom. And that's absolutely true, Your Honor. That's true in all these cases. And
it's true in every service industry. So that really can't be the test. That can't be how we decide if this is an employment relationship or an independent contractor relationship.
I understand. I only mention it because all the cases mention it when they're talking about the service for another.
Are those any of our cases?
They're all Colorado's cases.
Supreme Court cases?
There's only one Supreme Court case, which is Soft Rock.
And do you think, support this same proposition?
I do.
Maybe you could explain a little bit more how you think Soft Rock limits in the same way that employer services does, for instance, to service performed for the employer.
Well, Soft Rock was using a geologist for Mr. Ormsby for project work. And the argument, was that he was an employer of Soft Rock, or Soft Rock was his employer. And it turned out that was not the case. Mr. Ormsby was an independent contractor because he did do project work, did not have the direction and control of Soft Rock, and was customarily engaged.
And do you think Soft Rock turned on a single factor in that way, or as a threshold matter in the same way?
No, I don't. It was the totality of the circumstances in that case. There were a number of different factors. And the 9 factors that are mentioned in 870-115, 1C9, have periodically come up in these cases. They're not controlling, but they are factors to look at. In the CCM case, CCM, I think, were those 9 factors to be controlling, satisfied most of them in any event. So putting them into the totality calculus, I think, is helpful to CCM. So that's our view. And with respect to those factors, I think it was pretty clear by the record that the cleaners were engaged in an independent occupation, that they did not work exclusively for the homeowners.
Mr. Abrams, Chief, are you finished?
Yes, ma'am.
What I struggle with is the standard of review. I struggle with how much deference we should be showing the panel versus how much deference the panel should be according to the hearing officer. And so maybe you can help me with that a little bit. You know, I look at the standard under the APA in terms of what deference the panel is supposed to be showing the hearing officer, and I see this distinction between evidentiary facts and ultimate conclusions of fact. And there's reference to this in the briefs, but I don't really see any articulation of how we should categorize the critical facts here. Are they evidentiary facts? What becomes an ultimate conclusion or an ultimate fact? So can you help me with that? I feel like in compartmentalizing those things, maybe it helps us to evaluate what we should do with the competing inferences that the hearing officer drew versus what the panel drew. Do you understand?
I do, Your Honor.
Because I feel like, there are a lot of reasonable inferences here that are made both by the panel and by the hearing officer, and so I'm trying to decide whose inferences really count more.
Well, both the panel and the Court of Appeals, which build on the panel's decision, felt that there wasn't substantial evidence. Of course, we disagree with that. We think that the errors that the Court of Appeals made were just simply wrong. I mean, they misread the record in this case. The hearing officer, as the court knows, had an opportunity to examine this twice, and the second time considering the dynamics of the relationship and really looking at the totality. And it's pretty clear, at least in our opinion, that no employer would tolerate workers doing what the individual cleaners were allowed to do, and it was consistent with independent contracting to the totality point. They operated completely independently. With respect to the evidence that was presented at the hearing, the panel indicated that there wasn't substantial evidence, and that's a point of argument that in our reply brief, we set out in some detail by page and line the testimony of the 5 cleaners who testified that they did have their own businesses, that they were free from direction and control.
Let me see if I can't frame it a little bit more specifically. And so under the relevant portion of the APA, specifically 24.4.105.15b, what in your estimation constitutes an ultimate conclusion of fact in this situation?
The ultimate conclusion of fact was that, I think there was more than one ultimate conclusion of fact in the case, that these individuals were employees because they assigned these factors to them that they, for example, the fee issue, they made much of both the panel as well as the Court of Appeals made much of the issue that there was a one-time referral fee. A one-time referral fee was not paid. It was an ongoing, episodic, periodic payment. Well, that was true in all the other cases as well, but they ultimately determined that there should have been a one-time fee.
I don't want to monopolize your time, but I think you've answered the question. So it's the employee versus independent contractor determination itself that's the ultimate conclusion of fact, not the variables that we look at under the statute to ultimately get to that ultimate conclusion. Those would be evidentiary factual findings, the statutory factors, for example.
That's correct.
Okay. All right.
May I take you in a slightly different direction? And this has to do with the employer services case. That case seems to focus on whether there's some sort of third category, not an employee, not an independent contractor, but just not an employment arrangement whatsoever. It seems like the real fight in this case is simply whether we have an employee versus an independent contractor. All of the factual disputes seem to hinge on that distinction. So I'm wondering, what does employer services really add to that analysis as is relevant here? And do you need the employer services threshold inquiry to win here?
Well, as we read the employer services case, it struck us as being remarkably comparable and similar. I understand that there has been talk, not only in that case, but in some out-of-state cases, about a third category. I think the semantics of this discussion about third category in some of these out-of-state cases really misses the ultimate issue of, is this person truly independent from the domination of an employer? And we felt in the employer services cases, the case that was certainly true, no matter what you call the Marbles management. And it was certainly true in the CCM case. They had very little to do with the cleaners. Once the cleaners accepted an assignment, they were on autopilot from that point forward.
So is the analysis then in employer services essentially redundant of the employee versus independent contractor analysis?
I apologize, Your
I'm
Honor.
sorry, is the employer services threshold inquiry essentially redundant of the employee versus independent contractor analysis? Because it seems at the end of the day, you're under either this threshold inquiry or the standard test, you're focused on whether these individuals were independent contractors.
Well, that's what we have focused on, because the ultimate issue for the division is whether or not they're independent contractors or employees. That's the ultimate issue for the division and in its brief.
Thank you.
The statute uses the word service. Should we ignore that? What do we do with that? I mean, the part that employer services focused on, right, was the part that talks about the presumption. And, I think that comes from the Kirby case because of an argument that was raised in that case. And so do we just ignore that and go to the direction, control / independent trade test that we applied in Soft Rock? Or what do we do with that service aspect of the statute?
Well, all of these cases are basically service cases. And as opposed to manufacturing or some other delivery of a product, they're all service cases. And I think service, the services that all these individual workers provided is consistent with the question, well, in providing those services, were they independent? And that's, as we read the brief of the state, and our reply brief addresses that in some detail, that service is not a real distraction to whether they're employees or independent contractors.
But the statute says service for another, right?
Correct.
So do we care about that, or do we just assume that threshold, if you will, determination is made? Do we just make the assumption that's met, and then we move on to the two-part test that we applied in Soft Rock?
Well, no, Your Honor. I mean, I don't think we haven't assumed that the threshold test was met. We have looked at the facts. We feel that it was met because the service for another, that phrase is very important in the determination. The Reich versus Compton case talks about what it really means. They did generically, of course, provide service for another, but the another was the homeowner. It wasn't for, CCM. Is that responsive to the court's?
I understand your argument, yes, thank you.
Very well.
And Mr. Abrams, I think we've used up all your time.
Thank you, Your Honor.
Well,
Thank you, Mr. Chief Justice, and may it please the court. My name is Glenn Roper on behalf of the Industrial Claim Appeals Office. I think this case presents two main questions. Before I get to those, I want to address a factual point that Justice Gabriel raised, and that is whether Custom Made had the right to terminate the contract without liability. In its reply brief, Custom Made pointed out that I made a mistake in talking about the 10-day notice requirement. There is a provision that allows for termination upon a 10-day notice, but that is, as Mr. Abrams pointed out, for the cleaner to terminate. That's in paragraph 19 of the contract. Now, I would direct the court to paragraph 18 of the contract, which does provide that either party can terminate the contract upon written notice and does not contain a 10-day notice requirement. So although I was incorrect about saying that Custom Made had to follow this 10-day notice requirement, the principle is true that Custom Made could terminate the contract without consequence.
Can I ask you, since you're addressing my concerns, I want to jump in. I was going to ask you what Justice Hood asked Mr. Abrams about the standard of review. Your whole brief focused on deferring to the panel, and you almost ignored, I say that respectfully, almost ignored what the hearing officer found, and I have the same concerns Justice Hood was raising. This strikes me as a close factual case. Why shouldn't we be deferring to the hearing officer's findings here?
I think that's in this case, you have a statutory presumption that there is employment, and Custom Made bears the burden of rebutting that presumption before the ICAO panel. The panel, and this court held in Western Logistics and has said in other cases that whether that question is met, whether that burden is met, is a question of fact. And that would be, I think, one of the ultimate fact questions that Justice Hood was referring to. And under this court's cases, this court will not disturb the panel's decision unless there is no substantial evidence to support the panel decision. That was in the Allen Company, which this court cited again in Western Logistics, and I think the Samaritan Institute case as well addresses the same question.
So where's the limit of that argument? If the panel says we got facts on both sides of this case, arguably, and the panel says, well, we like these findings of fact better than these findings of fact, so therefore the ultimate conclusion is X. That feels like there's almost no deference to the hearing officer here.
Well, I think there is a need for deference, but the deference should be to the panel, which is the ultimate. They're the experts here, and they are reviewing the evidence and coming to their.
But why? And I'm just pushing on you, obviously, Mr. Roper. In this case, twice the hearing officer said, I'm seeing no evidence of control, the necessary control, and I'm seeing all this evidence of their acting independent, whatever the statutory words are, and there seemed to me to have been evidence to support that. Why does the panel get to say, we like a different conclusion? And I will say with great respect to the panel, there's a little bit of a feeling here of the panel just wanted to get to a result. And regardless of what the hearing officer said, they were going to get there. So push back, but I welcome it.
And I think, Your Honor, that the panel was not reversing determinations as to evidentiary facts, as to what exactly was going on, that what the company was doing. That wasn't the panel's role. It was more making an interpretation of what that means as to whether this constitutes control and direction, whether they are customarily engaged in an independent business. And the panel, because of its position, because it sees these cases day in and day out, and has a broader perspective than maybe the hearing officer in an individual case, I think it is appropriate for this court to defer to their view on those broader questions rather than the evidentiary questions of fact.
Well, the Samaritan Institute case in part talks about how in situations in which the evidence could equally support alternative findings, the hearing officer's finding may not be set aside. And the hearing panel did set aside some of the findings, and they use exactly that language. So I guess I continue to struggle with the same thing that Justice Gabriel has just articulated, that it sort of feels like a little bit of a coin toss on the facts here. Reasonable inferences can be drawn in both directions, and so we see reasonable inferences, I think, drawn by the hearing officer in the first instance, and then some different inferences that are drawn by the panel. And so you're saying that the panel's inferences count more because of their expertise. Is that?
It's not just their expertise, it's also their role, their position, which is to review these appeals and come to the final agency decision that is then reviewed by the Court of Appeals and then potentially by this court. And I would direct this court to the Court of Appeals opinion, which did review and concluded, applying what we think was the appropriate deferential approach, that the panel setting aside some of the hearing officer's findings was appropriate. The first question I think presented in this case is whether the act, the language of the act, requires a threshold inquiry into whether a worker does work for the putative employer, and there was some discussion of that already. If employer services means that you have to do that threshold analysis in every case, we believe it's mistaken and that the court should decline to follow it. The language of the statute does not indicate that there is this additional threshold prong that needs to be followed, and employer services appears to be an outlier in taking that approach. I would disagree with my friend on the other side's assertion that Soft Rock took this approach. There's nothing in the Soft Rock case that followed that same kind of analysis. I think it also creates an unnecessary hurdle, which is contrary to the statutory goal of protecting employees from the negative consequences of involuntary employment. Now, we're not saying that the service for another language is irrelevant or surplus, but I think where employer services went wrong is in treating that language as a third prong of the test and in conflating whether work is done for another with whether that work is employment. Both an employer relationship and an independent contractor relationship involve doing work for another, and some of Justice Marquez's questions touched on this point. In our view, all that the service for another language does is require a threshold, I shouldn't say a threshold, a common sense analysis of whether there is a working relationship between the worker and the putative employer. If, for example, there were no relationship at all, if a worker came and said, XYZ Corp is my employer, but there's no evidence or indication that there's any relationship between the entities, at that point, there wouldn't be a need to go through and do the employee independent contractor analysis. But in most cases, it makes sense, as long as there is a working relationship between the two, just to move to the two prongs of the statute. And in this case, we think it's clear that there was a relationship between Custom Made and its cleaners. But even if this court agreed that the employer services analysis needed to be applied, it is satisfied in this case. There's a stark contrast here between the facts in employer services in this case, and some of Justice Gabriel's questions touched on this point. In employer services, you had a talent agency that would provide a list of actors to a client that would then make the decision of whether to hold auditions, whether to invite them to auditions, and ultimately to hire them. The testimony was that the talent agency was doing work for the actors and not the other way around. And that's what you'd expect in the context of a talent agency, just like a sports agent working for an athlete or a booking agent for a band. Custom Made, in contrast, is in the business of cleaning homes. That's what the ICAO panel found, and that's what the evidence showed. And I think it's key that both Custom Made and its cleaners are in the business of cleaning houses. There was also extensive evidence in this case, which we cite on page 21 of the answer brief, showing that the cleaners did work for Custom Made.
Can you say a little bit about direction and control? The list of suggested habits, how is that control? For example, would a house cleaner be let go if he or she didn't follow those suggested habits?
Yeah, and I should note with the direction and control, there are facts on both sides here. But again, we don't think that it is this court's role to weigh the evidence, but simply to look at whether there was substantial evidence supporting the panel decision. And I think the right to control is best shown in the complaint resolution process. Where if a client called to complain about a cleaning, Custom Made wouldn't refer them to the cleaner, but would intervene and speak to the cleaner about it. In fact, one cleaner, Ms. Hernandez, testified, quote, if you didn't do something correct or up to par, Custom Made would then call you and say it needs to be done this way. And she also described an instance where Custom Made assigned her to go in and check the work of another cleaner and provide correction where there was a client complaint. Custom Maid's owners themselves also testified that if a cleaner didn't resolve a problem when a client complained, that cleaner would be removed and a different cleaner assigned to the client. And the panel found, after reviewing this evidence, that Custom Maid retained the right to direct the way the cleaners did the work to avoid losing a client. I think there was also other evidence of a right to control. When a cleaner applied to work for Custom Maid, they would be required to come and clean one of the owner's homes as a tryout, and then the owners would provide training and direction as needed. Custom Maid would provide potential clients an estimate. The owners would actually go to the home and provide an estimate to the client, and then they would set the price as to what would be charged for the cleaning. Now, Custom Maid claims that the cleaners could renegotiate the price, but there's no evidence that it actually worked that way, and it's hard to see what leverage a cleaner would have to renegotiate a price that had already been set.
Was the price set based on an estimate of how long the house would take to clean? Was it an hourly rate?
I believe that's correct. Certainly, they would look at what sort of work would be required, but there's no evidence that I've seen that there was anything other than time spent that the charges would be based on.
Yeah, I'm sorry, Mr. Roper, let me ask you, I'm troubled by some of these things that suggest control. You say a cleaner would come clean the owner's house as a check. Why does that suggest a statutory employment relationship as opposed to, before I put somebody on my list of contractors, I'm going to check them out? Why does that suggest that enough ownership and control? That strikes me as odd.
Yeah, it wasn't just a tryout. There was also testimony that was a training opportunity, and training is one of the factors that is addressed in determining whether there is control in this situation.
And did the hearing officer thought otherwise on that?
I'm sorry?
Did the hearing officer think otherwise on that same subject?
I can't remember exactly what the hearing officer concluded, and I don't mean to suggest that there was extensive training here. I think the evidence was just that there was this minimal amount of training. So I don't think it's a strong factor in favor of an employment relationship, but it is a factor.
All right, so I mean, just compare this case to Gross. I mean, there's extensive operational guidelines. There's a manual, as opposed to what was this called, helpful guidelines, including when you leave a room, take another look, make sure it looks clean. That doesn't strike me as the same kind of level of control we usually think of when you think of an employee. I mean, maybe you can address that.
I think you need to look at the industry here. This isn't a complicated industry, and it's a little different than what was at issue in Gross. And I think the suggestions or guidelines, or I would view them as directives if you look at the way that they're phrased, given to the cleaners. I think it's indicative of the level of control that Custom Maid wanted to exercise to make sure that they were doing what they should be doing. And the ultimate, Custom Maid, it was clear that if the client were to say do it a different way, they should do it that way. The customer is always right. But I think in the absence of other client directives, they did expect their cleaners to follow the guidelines and to clean in the way that they had directed them to.
But all right, I'm sorry, I'm just kind of pushing. So I'm still struggling with the issue of deference. Maybe what I'm struggling with is, why is the panel's expertise come into play here, as opposed to the hearing officer heard all these witnesses and said, this doesn't sound like control to me. Why does the panel get to override that, having heard none of the witnesses?
The decisions that the panel made and the rulings that the panel made weren't based on the demeanor of a witness, or it was more with the panel's broader perspective, reviewing these cases day in and day out, and in their expertise capacity in determining what makes an employee or an independent contractor.
But what gives them expertise over this industry, for example? That the hearing officer's looking and said, this just doesn't sound like control over these cleaners in this case. What gives the panel such expertise they get to say, oh, I think it was? I mean, why do they have special expertise? I understand what you're saying. They see these kind of cases. I mean, it just feels like they just weighed the evidence in a different way than the hearing officer, and your suggestion is we defer to them, and I'm struggling with why.
And I don't think that it is expertise in the cleaning industry. It is expertise in the law about employment relationships that the panel has and that they were able to apply in this case. And maybe it'd be helpful, I think, to step back a little bit. The reason that it was important for Custom Maid to exercise control in this circumstance is because the clients were Custom Maid's clients. and not the cleaner's clients. It was Custom Made who would go and do the estimate and figure out what job needed to be done. Custom Made would assign the cleaners to go and do the cleaning. And then if a cleaner left Custom Made, quit and decided to do something else, they were not allowed to take the client with them because they were Custom Made's clients. And the receipts that Custom Made provided to homeowners specifically said, you must not, as a client of Colorado Custom Made, directly engage or solicit the services of Custom Made's house cleaners. I should note that the direction and control is simply one of the two prongs, and Custom Made must meet both of them, bears the burden as to both prongs in order to establish an an independent contractor relationship. And we believe there is substantial evidence supporting the panel's conclusion as to the second prong as well, if I could turn to that. This court emphasized in Soft Rock and Western Logistics that this is not just a one-factor test. It is a multi-factor totality of the circumstances analysis. And here, the panel did exactly what it is supposed to. It looked at each of the factors, including the 9 statutory factors and the Longview Systems factors, weighed the evidence appropriately, and concluded that there was not evidence that these individuals were customarily engaged in an independent related business.
But, just to jump in there, for example, the first factor under the statute talks about whether there's an exclusive employment relationship, and then that morphs into, well, they had an ongoing relationship of a sort. And so I feel like that sort of goes to Justice Gabriel's point about how the panel seemed inclined to reach a conclusion irrespective of exactly what the statutory factors seem to require us to focus on.
I don't think that's correct. And as to the first factor, the panel actually found that weighed in favor of an independent contractor relationship. It was just outweighed by the other factors in the case. I'd suggest to the court that one way we can look at these factors, we can start by following the money here. Cleaners, in this case, would not directly invoice the clients. The clients would make out a check to Custom Made and make the payment that way. In fact, the cleaners were prohibited from directly collecting funds from the clients. Custom Made would then pay its cleaners an hourly wage, which is a factor that this court has talked about and is in the statute. In response to the audit questionnaires, numerous cleaners checked the box saying that they were paid an hourly wage, and there was testimony at the hearing that the cleaners were paid $11 or $12 an hour. There's also some discussion about this 47% issue. I would note, because the charges were always done to the clients based on an hourly wage, taking a percentage of that is just an hourly wage. And if you were, I don't know exactly how they set the prices, but if they were to charge the clients $25 an hour, 47% of that would be $11.75, which is right within the range that was testified to.
May I ask you just a factual question? So you said first, on the one hand, it's an hourly wage, and then you said you don't know how they set the prices. How do we know it's an hourly wage? What was the evidence of that?
And I didn't mean to suggest that we don't know how they set the prices. I just meant I don't know how this 47% number came about. But if it were a $25 an hour, then that would be consistent with an $11.75.
And was there evidence when CCM dealt with a client, they talked about here's our hourly fee is $25 an hour. It's going to be 2 hours. Was there evidence of that?
I didn't see any evidence of that $25 an hour number.
And I just made up a number, obviously, but was there some evidence that here's the hourly fee and this is the total number?
There was evidence that they would go to the homes and provide an estimate, and that it was based on an hourly calculation.
Okay.
And again, we cited the evidence in our brief, the testimony about the hourly wage and the check boxes there.
In a totality of circumstances test, are all the factors entitled to the same weight? And do we just count how many factors fall on one side of the ledger and how many on the other? Or do you think that some factors are entitled to more weight? And regardless of the answer to that question, how much weight do you think the payment arrangement is entitled to? How important is that?
So to respond to Your Honor, several questions there. I think this court has not specified exactly how the weight is to be allocated. I don't think it's just a numbers game of adding up factors on one side and the other, because as this court has emphasized, you look at the dynamics of the relationship and the totality of the circumstances. But I think here, the flow of the money is a significant factor, and I would suggest that this court should give significant weight to that, because that, how payments are made affects a lot of how an employment or independent contractor relationship works. And I think I would also point to the court to the fact that even if these cleaners had other side businesses that they were doing, they were always paid in their individual names. There was simply no testimony to the contrary on that. One of them even for a few months set up an LLC that she was operating under. Even in that circumstance, she was paid in her individual name. I would also point the court to the Longview Systems factors, which this court said in either Softrock or Western Logistics should be taken into account. I don't think Custom Made has disputed that all of those factors weigh against them. Now, they don't like the factors and want to say that we're in a new internet age. I would simply suggest this isn't an internet startup we're talking about here. This is a standard cleaning business, and those factors are relevant here as they would be in
So
other
I
cases.
know your time is about out here, but what CCM, it seems to me, did everything it could think of to make clear these are independent contractors. What do you think what else did it need to do? I mean, I can't conceive under your theory of how it would not be an employer in every situation.
I think they would have to change their business model. I think they could not do what they wanted to do here, which is exercise control to protect their reputation and keep their clients, and then not have it be an employer relationship. And we would respectfully ask the court to affirm.
Thank you. Appreciate the arguments of both counsel. The case will stand submitted, and I think we're going to move on to our next case, which is captioned Johnson versus the People. Y'all look arranged. We've set this for a 30-minute argument, so we'll give you 15 minutes each, and counsel for the petitioner, whenever you're ready. Go ahead.
Good morning, Mr. Chief Justice, Your Honors, Counsel, may it please the Court. I'm John Plimpton. My bar number is 48262, and I represent Ms. Johnson. I'd like to reserve some time for rebuttal, and I'll keep track of that. In this case, the trial judge defined hesitation to act in such a way that it is reasonably likely that the jury held the prosecution to a burden lower than what due process requires. And under Sullivan, this is structural error requiring automatic reversal. During jury selection, the judge informed the prospective jurors about 6 bedrock principles of the American criminal justice system that the jurors would have to follow whether they wanted to or not. One of those principles was the prosecution's burden. Initially, the judge instructed the jury that the prosecution had to prove Ms. Johnson's guilt beyond a reasonable doubt, and that a reasonable doubt is the kind of doubt that would cause reasonable people to hesitate to act in matters of importance to themselves. So far, so good. These instructions are standard and unobjectionable, but then the judge gave a non-standard instruction on what it means to hesitate to act. And he told the jurors that what hesitating to act means is that you would find Ms. Johnson not guilty only if you can't find her guilty because the quality or quantity of evidence just doesn't let you. That's when you've hesitated to act. It was this instruction that unconstitutionally lowered the prosecution's burden. It essentially told the jurors that they had to find Ms. Johnson guilty unless they could not because the evidence did not let them.
Mr. Plimpton, let me go ahead and jump in now. So let's say for the moment that you're right, that was more than just a nonsensical statement as Judge Dunn described it, right? And it created some momentary confusion. She also noted in the majority opinion below that it was flanked by correct instructions. So when you have something that maybe is misleading, but it's flanked by correct instructions, including a written instruction at the end of the trial that doesn't offer this additional layer of trying to explain what it means to hesitate to act, why doesn't that cure the problem in the sense that ultimately there was no structural error, no lowering of the burden of proof?
The short answer is that this definition tainted those otherwise correct instructions and undermined them. Judge Ashby wrote that the bad instruction created a circular logical syllogism that effectively eliminated the reasonable doubt standard articulated in those otherwise correct instructions. I agree with Judge Ashby that the reasonable doubt standard was effectively eliminated, but I think of it more linearly. Reasonable doubt was defined in terms of hesitation to act, and then hesitation to act was defined essentially as the inability to find Ms. Johnson guilty. So this was presented as sort of the ground level description of the prosecution's burden of proof. And I think the jury would have referred to this definition in interpreting the other.
Well, let me push back on you there. I mean, is that a reasonable inference, given that we're talking about the beginning of jury selection in a 3-day trial, that they're going to think at the end of the day about, oh, you know, I think that judge said something about this hesitate to act business at the beginning of all this? Does that stand to reason?
I think it does. I think there is a legal presumption that the jury remembers and follows the trial court's instructions. The trial was only 3 days long. I cited in the briefs to the 10th Circuit decision in Wansing and the 3rd Circuit decision in Hernandez, and I believe it was 3 days in Wansing. The trial was 3 days, and the instruction there lowered the burden. And in Hernandez, I think it was 4 days between the offending instruction and deliberations, and that also lowered the burden. I also think the way this was presented to the jury as a bedrock principle of American criminal justice, and they have to follow it whether they wanted to or not. It was really emphasized how important this was. I'd also like to add something that I've neglected to mention in the briefs, unfortunately, but I think it's important, and I think it makes it more likely that the jury followed this instruction. And that fact is that everyone who sat on the jury said under oath that they would follow the instruction. At the beginning of jury selection, the judge placed the prospective jurors under an oath to tell the truth, and this discussion of the bedrock principles was actually a preface to a question. Actually, the judge individually polling the jurors about whether they would follow these instructions. I think there was one who said she wouldn't or couldn't follow them, and she was dismissed from the jury pool, and all the others said they would follow them. So I think it stands to reason, yes, that they would follow this.
Mr. Plimpton, if I can jump in here. So let me tell you what's troubling, at least I have trouble with. I am concerned about this instruction, but I'm also, it strikes me as gibberish. I mean, with all due respect to the trial judge, it's all over the place. You've both had discussion in your briefs about whether when he said guilty, he meant not guilty. I guess my question for you is, can we really say this lowered the burden when it's nonsensical, as Judge Dunn found? I understand your point. The judge said it was a bedrock principle. He said you got to follow it. There was no other definition of hesitancy to act. If there was a pretty clear instruction of this was clear what the judge was saying, I'd probably have less trouble. But given that it just on its face it's so confusing, I'm a little concerned about how we get to saying this lowered the burden, given that how it was all over the place.
Well, I think you're right that on its face it was confusing, but that's not how I read the instruction, and it's not how the prosecution reads the instruction. I mean, on its face, you could read the instruction to say you would find Ms. Johnson guilty only if you can't find her guilty, and that is nonsensical. Judge Ashby pointed out that you could also read it to say you you would find Ms. Johnson guilty only if you hesitate to act, which I think would be problematic. In the
Sure,
long run.
and I agree with you. I think you both read it had to be not guilty. But both the majority and the dissent below seem to have assumed guilty. I mean, the logical syllogism that Judge Ashby referred to, I think she was assuming the word was guilty, in which you're both saying was actually not what it meant. So it's just really confusing.
Well, I disagree that Judge Ashby only considered the possibility that it said guilty. I think some of her
She
points
went to both.
address-
I agree with you. I was just talking about the logical syllogism.
Right. But I think, I guess, my most straightforward answer here is that I think it's clearly not what the judge meant to say guilty. He meant you would find her not guilty, and I actually don't think that's confusing. To say you would find her not guilty only if you can't find her guilty because the evidence doesn't let you, that's not legally correct. It might seem nonsensical to us legally trained people, but I think to a juror that's kind of intuitive. Well, if I can find her guilty, then I have to. So I actually disagree that the most plausible interpretation of the instruction is confusing.
But isn't what's important here for us what the judge actually said? Well, let's assume the judge meant not guilty. But if the judge said guilty, and that's what the transcript shows, that's what we have to assume the judge said, right? We can't assume that, or I don't know what relevance it has, what he may have meant. And I don't think we can assume that the transcript is incorrect. Don't we have to take it at face value that this is what the transcript says, so this is what he said?
Well, no, because in Victor v. Nebraska, the U.S. Supreme Court said the constitutional question in the present case is whether there is a reasonable likelihood that the jury understood the instructions to allow conviction based on proof insufficient to meet the Winship standard, insufficient to meet reasonable doubt. So the court has to look at how the jury would have understood the instructions, and it's not limited to considering the words at face value.
But in considering what the jury understood, we have to first figure out what the judge said.
That's correct. But I think one of the things that the Supreme Court said in Francis v. Franklin is that a jury would try to make sense of a confusing earlier portion of instruction by reference to a later portion of the instruction. And the later portion of the instruction clearly said, you can't find her guilty because the evidence doesn't let you. That's when you've hesitated to act, and that would clarify for the jury any confusing earlier portion.
So let me jump in, because help me understand how that latter half of the instruction is improper or lowers the burden of proof. Could you not read that to say, yeah, if it doesn't meet a certain threshold, you cannot in fact find her guilty if they haven't proven it beyond a reasonable doubt?
Well, the threshold that was created by that latter portion of the instruction, I think that threshold is unconstitutional. And the reason being, I gave 4 reasons in the brief. The first is that it's simply not what hesitating to act means. It's not being unable to act. You can hesitate to act while still being able to act. The second point I made was that it shifted the burden of proof because it makes it sound like it's creating a presumption of Ms. Johnson's guilt that can only be rebutted if the jurors find that they can't convict her because the evidence doesn't let them, whatever that means. But it makes it seem like there is a burden on Ms. Johnson to present evidence that could let the jurors acquit her. I also think this sort of, it's a bit amorphous about, and in that sense, it's about what the jurors could do because the evidence let them. In that sense, it subjectivizes the burden of proof, similar to the instructions in Wansing and Hernandez that were found to lower the burden of proof in Wansing. I'd just like to emphasize again, that was on habeas review, so it was an extremely deferential standard, and that still lowered the prosecution's burden and required reversal. And also, I think it just takes the concept of hesitating to act out of the context in which it's helpful for understanding a reasonable doubt, which is reasonable people hesitating to act in matters of importance to themselves, and makes hesitating to act about deciding whether Ms. Johnson's guilty. So for all those reasons, it lowered the burden. But I also want to be clear. I think it's just, I read this and I just thought that's not what due process means. that's less than due process. So I think it's kind of intuitive.
And since you're short on time, let me just ask a quick follow-up question, because I see this instruction as kind of two parts. The first part being this ambiguous guilty, not guilty statement, and then the second part, you can't find her guilty because the quality or quantity of evidence just doesn't let you. If we were to assume that the first part is just nonsensical, or we can't really understand, we're not sure what it means, if you're just left with the second part, do you still win with that alone?
Yes. Because that's the part they understood, and that lowers the prosecution's burden. That makes hesitation to act being unable to find Ms. Johnson guilty based on, because the evidence doesn't let you. Yeah.
But read the whole sentence. I mean, picking up with Justice Marcus's point, you just can't bring yourself to do it, meaning find her guilty. You just have to hesitate. It's not there. That would kind of suggest if you have any doubt, you have to find her not guilty.
I think it means if you have any doubt, you have to find her not guilty, is what you said?
Yeah, the second part seemed to have kind of fixed. We start now talking about not guilty. I think you can't find her guilty if you have any hesitancy. Would seem to be a natural way to read that.
I think it says, the way I read it is you just can't bring yourself to do it, as in you just can't bring yourself to find her guilty, because it goes on to say you just can't bring yourself to do it. You have to hesitate. It's not there. You can't find her guilty because the quality or quantity of evidence just doesn't let you. That's when you've hesitated to act. So I think you have to read that as a whole. I mean, that's how we read jury instructions. And so, all right.
Okay, thank you.
If there are no further questions, I'll reserve. Thank you.
May it please the court. Carmen Moraleda on behalf of the people. My attorney registration number is 34852. It's good to be back. I would like to begin my argument by telling this court, since I know you like rules, the rule that we are asking it to adopt. And it goes like this. To the extent there are differences between the trial court's explanations of law during voir dire and the final jury instructions given to the jury at the close of the evidence, it can and should be presumed that the jurors followed the final instructions. As this court knows, Rule 24 of the Rules of Criminal Procedure require trial judges during voir dire to explain to prospective jurors the general legal principles that apply in a criminal trial, and also to determine which jurors are qualified to serve on the jury. In turn, Rule 30 provides that before closing arguments, the court shall read instructions to the jury and then give them a copy for them to use during deliberations. Here, when you look at the context of the trial court's voir dire comments, and you compare the trial court's colloquy with the formal reading of the jury instructions, you can tell that the explanatory comments were not meant to be instructions per se. Unlike the voir dire comments, the formal reading of the jury instructions clearly, unambiguously, and solemnly directed the jurors to follow those instructions as the law it had to apply.
So let me push back a little on you, Ms. Moraleda, and good morning. The court, as Mr. Plimpton said, did say, here are the 6 bedrock principles that you have to follow, and everyone, you need to agree that you're going to follow them, and then gives this definition of hesitancy to act. I like the rule you proposed, but I suppose the problem I have in this case is there's no other definition of hesitancy to act. So, and again, I'm playing devil's advocate with you. The court says, here's the bedrock principles. Here's my definition of reasonable doubt. Here's hesitancy to act. Gives written instructions that are not inconsistent with this definition of hesitancy act. There is no other definition of hesitancy act. Why do we not, we say often, we presume the jurors follow the instructions. The judge said it's a bedrock principle you have to follow. Why do we not presume the jurors follow that definition?
Well, so if you look at the whole voir dire comments, I don't think the trial court, as it did with the formal reading of the instructions, directed the jurors to follow the instructions as the law it had to be applied. For example, during the reading of the instructions, the court clearly told the jurors that, first of all, listen carefully to the instruction I'm going to give you, but don't feel that you have to memorize them because I'm going to give you a copy. And then the judge charged the jury, telling them, in a moment I will read you the law which you must apply in order to reach your verdict. And then it said, your decision must be made applying the rules of law which I now give you to the evidence presented at trial. However, or regardless, even if those comments were instructions per se, in the technical sense we all understand instructions, they were not clearly erroneous. I think even grammarians would disagree as to the possible interpretations, but they did not lower the prosecution's burden of proof. And most importantly, when read in context with the other instructions, correctly instructed the jury on reasonable doubt. So,
Well, you go ahead. No, you please.
right.
To go back to your proposed rule, if I understand you correctly, you're saying, forget about whatever happened at the beginning of trial, let's focus only on what the instructions were given at the end of trial, right before closing arguments or deliberations, right? Is that essentially the rule you're asking the court to adopt?
Well, we're not saying like forget about what the court said during verdict completely.
You use the word presumption.
Yeah, well, here's my question. Let's say, for example, you gave a proper reasonable doubt instruction at the beginning and the trial court forgets to give any reasonable doubt instruction at the end.
Yes. I mean, if the judge...
I would imagine you'd be in here saying, no, that was a great instruction. We should pay attention to it.
If the judge during voir dire says something that is plain and clearly wrong, I mean, that could rise to the level of a due process violation. Like, for example, in this case, the judge first provides a proper definition of reasonable doubt, but then says, well, you know what? At the end of the day, reasonable doubt, whatever you feel, whatever your guts tell you. I mean, that's clearly wrong. So in that case, I mean, the error can be a constitutional violation, even though the court provided the correct instructions later. So there are going to be situations where the record clearly supports that something was just not right.
Okay, so the rule you initially proposed would be subject to exceptions if the thing that was said at the beginning was clear and incorrect. The issue here is that it wasn't clear and incorrect. It was incorrect and totally confusing.
Yes, of course, like we hardly have rules without exceptions.
Well-
But yes, Your Honor, yes.
May I piggyback? So I have a similar question, and that is, in the brief, you talk about Estelle versus McGuire and how you can't look at things in isolation. We have to look
Yes.
at the totality of the instructions and the record as a whole. So I guess I just find myself wondering how it is that you come to articulate a proposed holding that involves a presumption. That seems to fly in the face of Estelle versus McGuire and its progeny. So how do we reconcile those things?
So Estelle is, the rule is that if you have an instruction that is ambiguous, I guess the standard is, was it reasonably likely that the jury would have interpreted in a way that lowered the prosecution's burden of proof? That's the question. But the reason why we have to separate generally the comments that the judge makes during voir dire versus per se instructions is that the analytical framework is a little bit different. Instructions, we look at all the instructions to see and as a whole correctly instructed the jury on the law. The voir dire comments generally look like any other trial errors to see if they affected the defendant's substantial rights or his right to a fair trial. So those comments, unless they're clearly and plainly erroneous, you look at the whole record, the whole trial. But the question of the instructions is a little bit separate analytical framework. And I don't know if this answers your question.
Thank you. I understand your argument.
All right, so unless you have questions, it takes me back. So assuming the jurors here, first remember the comments verbatim. Just keep in mind that the jurors did not have the benefit of the transcripts and did not get an instruction on hesitation to act. And also that they parse out those comments, it's just not reasonably likely that the jury would have interpreted the comments the court made in a way that lowered the prosecution's burden of proof. Because in the end, the court clearly unambiguously and correctly told the jury that the prosecution had to prove guilt beyond a reasonable doubt.
But it didn't give an instruction on hesitancy. So let me ask you it this way. If the instruction here was clear, or what the court said was clear, that hesitancy to act means unable to act, do you think that would lower the prosecution's burden of proof, as Mr. Plimpton says?
Well, I think, Your Honor, you have to look at the, in context, everything the court said.
I know, I just if I can get an answer to that. If the court said hesitancy to act means unable to act, does that lower the prosecution's burden?
No, it does not.
Tell me why.
It doesn't lower the prosecution's burden of proof. And that kind of takes me, and I'm going to give you a few examples. And this kind of also goes to why this is not a structural error. Structural error applies when an actual instruction effectively lowers the prosecution's burden of proof. And I'm going to give you a few examples of what kind of instructions have been held to lower the prosecution's burden of proof. For example, the instruction in Cage, the U.S. Supreme Court case, which equated reasonable doubt with grave uncertainty, actual substantial doubt, and also required a moral certainty as opposed to an evidentiary certainty. Now, the comments in Wansing, the Third Circuit case, defendant cites in the reply brief. There, the trial court analogized reasonable doubt to a doubt whether to call off a wedding. And the problem there is that Oklahoma law prohibits instructions on reasonable doubt. So there was no correct instruction that could have dispelled the misleading definition given by the court. The comments in Hernandez, the Third Circuit case, cited by the defendant in the reply brief, where the court told the jury that proof beyond a reasonable doubt was they determined in their own heart, soul, spirits, and own judgment. Nothing like that in this case. The comments, whether an instruction or just an explanation, did not lower the prosecution's burden. At worst, they were ambiguous. And that's kind of the examples that I had where the courts have concluded that lowered. But anything else, even in Victor, Nebraska, the court concluded that the reasonable doubt instruction, which contained language that in Cage have been held unconstitutional because it provided context, it didn't lower the prosecution's burden of proof. But the same here. The comments, even if they are confusing, ambiguous, did not lower the prosecution's burden of proof.
So, more later, I'm going to follow up on your question. Would you agree that unable to act and hesitant to act are not synonyms? They don't mean the same thing.
Unable to act
And hesitating to act do not mean the same thing.
Yes, they are not the same thing.
Then how does unable to act, again, using Justice Gabriel's hypothetical, not lower the burden for the prosecution if they were to give that instruction? And it goes uncorrected.
Well, because you have to read everything in context to make sense.
I'm asking in that isolated piece, how is that not, does that lower the burden?
No, so could you ask the question again, please? I want to make sure that
If the court said, not this convoluted thing that was said, with all due respect, said, basically hesitate to act means unable to act, and it goes uncorrected, would you agree that that lowers the burden?
Let me just think about it for a little bit. Hesitate on matters unable to act. I don't think it would. I don't think it would actually would be raising the prosecution's burden of proof.
Would it depend on how it's phrased? So, for example, if the instruction were, you must find the defendant guilty unless, you would hesitate to act, as opposed to, you must find the defendant guilty unless you are unable to act.
And your question was?
Does it change, does it matter if you're saying you must find guilty unless or not guilty unless?
I don't think so. And I understand that, I guess, the questions this court has, but that requires that some kind of very technical interpretation that is just not reasonably likely that the jury in this case, because it wasn't given that as an instruction. If the jury were given this as an instruction, maybe we could be kind of speculating as to how the jury interpreted, but they didn't. This was a comment in passing during the voir dire, and at the end of the trial, they were given the correct instruction. And as this court knows, trial judges are not required to use specific words, only instruct the jury that the prosecution has to prove guilt beyond a reasonable doubt. So hesitation to act is not language that is required. And also this court said in 1920, reasonable doubt is something that most people understand, but is not easy to define. And here, in looking at the whole, the instructions as a whole, and also the reasonable likelihood that the jury would have interpreted it in a way to lower, it's just not likely, and all the instructions as a whole correctly instructed the jury on reasonable doubt. So unless there are any other questions?
Well, why don't you remind us at the end here why it is that you think that, if anything, what he said could actually be construed to heighten the prosecution's burden of proof?
What the,
Why did it, you made the argument in your brief that it could actually be construed to say they have a higher burden of proof. So just remind us as you finish why you think it might have done that.
well, because, let me just read this real quick in my mind. If you are, if the jury, if the definition went unable to act versus.
No, never mind all that. I'm not talking about hypotheticals. I'm talking about the language he actually used that we have in the transcript. How could that be construed to actually say that it heightened the prosecution's burden?
Well, because when you read it, I think the court was telling the jurors that they have to have a near certitude that the defendant was guilty before finding her guilty. The language they use in terms of the evidence, the evidence, you can just bring yourself to do it, you just have to hesitate, it's not there, you can't find it guilty, because the quality, he talked about the quality and quantity of the evidence, just doesn't let you. So that way, to me, the way I interpret is that it was saying to you, you have to be very close to certain before you can find defendant guilty.
Thank you.
So with that, we ask that the Court of Appeals judgment be affirmed. Thank you very much. Oh, my God.
Plimpton, rebuttal?
That's all right.
I wasn't pounding a gavel there.
Neither was I.
Would the bailiffs please bring a paper towel for the justice? Thank you.
Should I wait on that?
And no, please.
Please proceed.
I think it's important to realize, and there seems to be confusion, hesitation to act is a standard for determining when a jury has a reasonable doubt and therefore must acquit. So the prosecution is, I think, simply wrong that being unable to act, defining hesitation to act as being unable to act could raise the prosecution's burden. In fact, it would raise the bar for acquittal, which correspondingly lowers the bar for conviction. And I'd just like to briefly address the prosecution's argument that this is just a comment during voir dire. I don't think that's true on this record. It was described as a bedrock principle. The jurors took an oath to follow this definition. And the 10th Circuit specifically rejected this distinction and the Third Circuit did too, on the ground that it kind of elevates form over substance here. The jurors wouldn't draw that distinction.
Respond to the certitude point. She's saying that it should be construed to amount to near certitude. And that language at the end that we've talked about so much of what the judge said does seem to suggest that almost any doubt that causes hesitation would be enough to render the defendant not guilty. So why is that not a fair reading of what the judge said?
Well, you can't find her guilty because the quality or quantity of evidence just doesn't let you. That's when you've hesitated to act. So you hesitate to act when you can't find her guilty. And so I think that's,
Okay.
they had to find her guilty unless they couldn't. I don't think that's due process. All right, ask the court to reverse. Thank you.
Thank you. Appreciate the arguments of both counsel. Case will stand submitted, and the court's going to be in recess for 15 minutes.
State of Colorado is now in session. Chief Justice Post presiding.
Thank you. Please be seated. Next case on our docket is styled Colorado Department of Labor and Employment, the Division of Workers' Compensation versus Dami Hospitality. We've set this for 1 hour, so we'll be 30 minutes aside. And I wanted to let everybody know that Justice Hood will not be participating in this case. Mr. Lee, when you're ready.
Thank you, and may it please the court. John Lee on behalf of CDLE, the petitioner in this case. The first two issues in this case are like two tugging ends of the same piece of thread, because no matter which side you pull, it ends in the same knot. Because if, as we argue under the first issue, that corporations are different than individuals for the purpose of the Eighth Amendment's excessive fines clause, then the Court of Appeals applied the wrong standard, and then the opinion must be reversed. If, on the other end, the excessive fine clause applies to corporations because they're treated for the same purposes under that clause because they're the same as individuals, then necessarily the same test that applies to individuals under that clause should also apply to corporations. And then the Court of Appeals again applied the wrong test, and it should be reversed. Because under that well-founded standard, including looking not at the aggregate, but at each individual fine to each offense, there's really no dispute that in this case it is proportional. And even aside from those first two issues, as we submitted in the brief, even if this court were to apply the Gore test, as the Court of Appeals did, under a correct weighing of that test, the fine should have been affirmed and the Court of Appeals opinion should now be reversed.
Mr. Lee, before you get up a big head of steam, could I ask you to address, the U.S. Supreme Court has granted cert to decide the question of whether the Eighth Amendment even applies to the states. Does that have any impact in this case at all? If so, how?
Absolutely, and we supplement authority with that case.
Right.
It's relevant to this case arguably in two different ways. First, should they find that the excessive fines clause is not incorporated to the states, it moots this case. If it doesn't apply, then the Eighth Amendment just doesn't apply in this case as a Court of Appeals because it was only argued under the federal Constitution. The Court of Appeals opinion should just be reversed. On the other hand, and I think it's more important to our argument as to why the excessive fines clause would not apply, the issue in Timms is whether or not the excessive fines clause is incorporated to the states. The test is for whether or not an amendment is incorporated is whether or not the right is so fundamental that it either is necessary to a secured order of scheme of liberty or that it's so ingrained in our nation's history and tradition that it is in fact fundamental. I think what's interesting about this case is if we put corporations in that box as being protected under the Eighth Amendment, then the excessive fines clause probably is not incorporated through that test. Not finding corporations isn't necessary to a secured scheme of liberty. It's also not ingrained in our nation's history. I think evidenced by the simple fact that this was the first case that ever held expressly that the excessive fines clause applied to corporations. There is not a long-standing history and tradition of using the Eighth Amendment to guard against excessive fines placed on corporations.
So what in the text of the Eighth Amendment makes this not applicable to corporations? I mean, sometimes the Constitution will say no person shall. This just says excessive, well, the relevant part, excessive fine, nor shall excessive fines be imposed. It doesn't say against whom. So why doesn't the plain text say excessive fines can't be imposed against anyone?
It's not just an issue of plain text, as I think all the cases cited throughout all the briefs show. Really, the key is the framer's intent. So it's not that it's not necessarily excluded or included by the language, because as both sides agree, the courts, U.S. Supreme Court's kind of gone both ways, whether or not the text does or does not include corporations.
Well, does it? I mean, I understand it's, the excessive bail clause can't apply to a corporation because you can't put a corporation in jail. That just makes sense. But I'm not sure I've seen a case that would suggest otherwise in terms of the Eighth Amendment.
It's as it applies to all amendments. So there is no dispute, there is no case directly dealing U.S. Supreme Court case with whether or not the excessive fines clause includes corporations. But as with all constitutional interpretation cases, the key is the framer's intent. I mean, the court can't say what it can't rewrite the Constitution. So if the Constitution means anything, it's that it's the standard that they believed would apply. So in all those cases, including all the ones where the U.S. Supreme Court has found it to apply to corporations, it was because the U.S. Supreme Court could find, based on historical, demonstrable evidence, that the framers intended to include corporations. The problem in this case is there's absolutely no argument either by the Court of Appeals or by respondents or by the amici that there's any historical evidence that the framers intended the Eighth Amendment excessive fines clause to apply to corporations.
What would be the reason that the framers would want to avoid having the government excessively fine individuals, but wouldn't worry about the government excessively fining the businesses run by those individuals?
The issue, there's really only two U.S. Supreme Court cases on point. It's Browning-Ferris and it's Austin. And it kind of details the limited history we have about the excessive fines clause. And both those cases, particularly Browning-Ferris, and then I'll get into, I think Austin does as well, goes into the whole purpose of it was, the primary purpose was to prevent the historical use of fines to keep people in prison. That's what Browning-Ferris says. If we look back to what the framers were thinking, it was the Star Chamber, it was the Stuart Kings using against their political dissidents to keep people in prison. So unlike people, corporations can't go to jail. So that's one reason why the framers did not and would not have intended it to apply to corporations.
What do you do with the language, I'm going to butcher the name, Bajikachian case from the U.S. Supreme Court, which says the excessive fine clause limits the government's power to extract payments, whether in cash or in kind, as punishment for some offense? That's broader than just keeping them in jail.
And I would point to offense. And Baha Kajan was dealing, again, with a forfeiture, which I think puts us back into the other case I was discussing, which is Austin, which I will say does present a slightly broader picture of the Eighth Amendment than Browning-Ferris. But even then, in that case, and again, I think this is the key throughout, because really the battle is what is the test that applies to interpretation? And even in Austin, why the U.S. Supreme Court did what they did is they actually found a historical basis for the framers' intent that they wanted in rem forfeitures to be protected under the excessive fines clause. And I think it's a narrow holding that followed the same test. But the key is that they actually looked and found that based on the history of searching ships and taking items based on an offense, that the framers had intended, I think, 3 threshold conditions for that holding to apply. And that's one, that the framers did in fact intend it, and then what did they intend? That there was a taking based on something tied to a criminal act against an individual. And there needed to be historical evidence supporting all 3 of those limitations. And in this case, none of those are present. There is no evidence that the framers ever intended to include corporations from an excessive fine clause. Although one of the issues in Austin was whether or not in rem forfeitures were in fact considered to be excessive fines clause because it was in a civil proceeding, nonetheless in that case, and I think this was the court's concern, is regardless of how it was framed, that case was tied to a criminal case. In rem forfeitures are by their nature a byproduct of a criminal offense. In that case, the defendant had dealed drugs from his house and his business, and after being convicted, the government sought to forfeit both his house and his business. So again, although not necessarily just a criminal act, it was tied to a criminal act and a criminal prosecution, which we don't have here. And again, in that case, the other thing the court found was, again, that the framers did intend to include an individual. And again, we have none of that here. Now, respondent takes Austin a bit further and argues that the U.S. Supreme Court created a new test and said that the excessive fines clause applies so long as it constitutes punishment. There is some language in the opinion saying that, but I think from the context, as I said, those 3 threshold limitations just aren't present. We don't even get there unless there's some evidence that the framers intended it to apply, because in that case, the beginning, the linchpin is the fact that they found the framers did intend it to apply to certain in rem forfeiture proceedings. But even assuming that this court goes far beyond what I think the U.S. Supreme Court intended and does apply that test, another important takeaway from Austin is how they define punishment in that instance. It wasn't just any kind of punishment, and that makes sense because the third clause of the Eighth Amendment is punishment. So if excessive fines was just punishment, that makes no sense to say that there shouldn't be excessive bail, punishment. It was a different, more meaningful thing that the framers intended when the court talks about it in Austin. And how they define punishment in that case, and that's really all the discussion in that case, is it's dealing with the framers intended punishment in that context based on the First Congress and their laws to be based on whether or not the taking was tied to a criminal act and whether or not innocence would be a defense. That is, whether the taking could be based on a guilty mens rea. And that's why the court went through its long discussion about the guilty property fiction and whether or not under both common law and current US law, the taking could have taken place if the owner was just innocent. That alone, even assuming that test does apply to this case, that test wouldn't apply here. Because in this case, although, as I'll argue, we certainly believe that Dami did engage in culpable conduct, it's a strict liability offense. The fine attaches whether or not the person reasonably acted. So I think that alone takes this case out of Austin, even assuming Austin does apply, which we believe it doesn't. So to back up a little bit and just quickly go through the different tests before this court, because I think that really is where this turns. There's 3 briefs, there's 3 different tests. In my mind, there's really only one test that's been prevalent through all the cases, and it's the only test that makes sense, which is what was the framers' intent. But I'd like to start by saying why their tests are wrong, and then why our test is right, and why the factors should yield that result. The respondent's test is, and they say on page 12 and 21 of their answer brief, is that this court should apply a special test beyond just intent because it's been a big trend in U.S. Supreme Court case law to extend it to corporations. That's not a legitimate ground for interpreting the Constitution. If you look at the cases that they cite, that just bears it out and bears out that there's only one real test. They cite cases dealing with the First, Fourth, Fifth, and 7th and 14th Amendment. All of those cases only found that they extended to corporations under those provisions because the framers intended. So under the 4th Amendment case they cite, Marshall, the U.S. Supreme Court said that that extended to corporations because the framers clearly intended it to based on the English writs of assistance, where they would search places based on the idea of smuggled goods against businesses. So again, there's an express finding that that was what the framers intended. Under Ross, and Martin Lennon and the 14th Amendment case, Southern Pacific, again, in all 3 cases, the United States Supreme Court expressly found that the framers intended to include corporations within those amendments based on express historical evidence. The closest cases they get to are the First Amendment cases, and that's really where the Court of Appeals opinion kind of turned, what they called a title shift in First Amendment law covering corporations. But I think as respondents' own brief shows, it's anything but a title shift. It's 74 years of case law repeatedly holding that the First Amendment was intended and was necessary to include corporations. It begins with Grosjean in 36, Button in 63, Bellotti in 78, and then Pacific Gas in 86, and then ends in United Citizens in 2010. I mean, in all those cases, it's the same holding. There is no trend, there is no title shift. Amicus's test fares no better. Their test is if it says shall, kind of not quite going a bit further than as Justice Gabriel's question suggested earlier. But even as their own brief recognizes, that's not true. That doesn't hold. They admit it doesn't apply to bail. They admit that it wouldn't apply to the Fifth Amendment's capital punishment clause. I think we all could agree it wouldn't apply to the Second Amendment. You wouldn't have a right to have a gun as a corporation independent from a person. And it wouldn't apply to the 26th Amendment. Corporations can't vote. Their fallback position is the court should apply an amendment whenever it could be applied to a corporation. And again, that's not correct either. The issue is whether or not the framers intended. You could theoretically apply the 26th Amendment to corporations. Citizens United turned 18, I think, in 2004. They didn't have the right to vote. Facebook can't vote in 2022. Just because you could apply it doesn't mean you should. And again, the whole point of constitutional interpretation is what was intended.
But I just find it interesting that what I'm not hearing you focus on are the words. I mean, the first test is what it says. Excessive bail shall not be required, nor excessive fines imposed. Thou shalt not impose excessive fines, period. I guess I'm having trouble understanding what's confusing about that.
I think there could be no dispute that at a minimum it's ambiguous. As we pointed out in the brief, I think what informs the text are its neighbors. The first clause and the third clause, everyone agrees, would not apply to corporations. I think that alone creates ambiguity. I think the historical context of corporations alone, I mean, it doesn't say corporations. Corporations didn't exist back then as they do now. I think that also creates ambiguity. So I think as a matter of constitutional text, you always have to look at the history and the framers' intent, but even assuming this court were to say we can look only when the text is ambiguous, which I don't think is a correct test, the text here is ambiguous. So you do have to look at intent, and there's just no evidence that it was intended.
Let me take you in a different direction if I can, Mr. Lee. Let's assume, for argument's sake, we disagree with this argument. We have to figure out what test would apply to decide if it's an excessive clause. Could you address that? I find it interesting that the Court of Appeals went to the due process cases, the Gore factors. Baha Kajian sounds like a better way to pronounce it to me. That case would talk about gross disproportionality. So were we to disagree, what test would apply for deciding if this was an excessive fine?
Yeah, and just to segue into that issue and to close out the first, we would certainly say that at a minimum, this court did not want to hold that the Eighth Amendment did not apply, then because it could assume without deciding, based on the second and third arguments, it certainly could say that and kind of implicitly reject the Court of Appeals' reliance on that ground as well, which I think would be well-founded considering no court has ever said that. But on the second issue, we believe that when dealing with the excessive fines test, that the excessive fines test should apply. That's the test that the U.S. Supreme Court applied, and how I heard it said online was Baja Kajan.
Okay.
So that's what I'm going to go with, but I
Thank
have no
you.
idea what it is. That the Baja Kajan test should be the one that applies. Now, respondents called an empty argument. I don't think it's empty to say that the excessive fines test should apply to the excessive fines claims. I mean, I think that's actually a rather full argument. Their only complaint to it is that this court should reject it based on the Court of Appeals' historical application of it, citing to one case from 2005, Associated Press. I don't think that's historical. Even if it is, that's not a reasonable basis for this court to affirm. If a lower court's holding was enough for this court to affirm, again, there would be no purpose. To the extent it is historical, that only highlights the need for this court to correct it because
So-
it is the wrong test.
Can I interrupt and ask?
Yes.
Let's say we agree that the excessive fines test should be applied in an excessive fines case. What is the content of the determination of whether something's grossly disproportionate?
You look at so I think as the U.S. Supreme Court said in Bajak Jan, they cite to say that it's the correct test, that it's the test that applies for the cruel and unusual punishments under Solemn. So it's the criminal test that we normally use for criminal punishments, and there's two features to that that are important. One are the factors. It looks to different factors than the Gore test, which makes sense because, as we pointed out, the second Gore factor is wholly inapplicable to excessive fines because there is no plaintiff and there are no damages. But you look at the gravity of the offense, and this would be for an extended, because I think arguably you could have an abbreviated if you're truly incorporating all of the Solemn test. So the abbreviated would be that you look at the gravity of the offense, and if the offense is grave, then you're done. If there's questions as to whether or not there is proportionality between the nature of the offense and the fine, then it's extended proportionality review where you go to the second and third factors. The second factor is compatibility with fines within the same jurisdiction. The third one is compatibility with fines outside the jurisdiction. And I think in this case, their claim fails both abbreviated and extended proportionality review.
Would ability to pay factor in at all?
No, it does not. The Supreme Court has never said it does, neither for, and I guess it's interesting, neither for Bajak Kajan or under the Gore test. That's something that the Court of Appeals added. If you look at the cases that they cite, there's no constitutional underpinning requiring a court to consider ability to pay unless there's a deprivation of liberty in those contexts. All the cases they cite, it's either because they're found implicit statutory authority, and that's the Malone case, which they cite in Bolt and Boulder Association, where there's the general offender statute saying consider the individual characteristics. So it's certainly within the General Assembly's prerogative to decide whether or not ability to pay should be considered absent a liberty deprivation. And here they've decided that it should not be considered, and it should not be considered.
Well, let me just push back a little bit on that. So let's take a hypothetical. You got a mom and pop shop, and the fine is, $30 billion. Some, extreme, where it really is a corporate death penalty. Why wouldn't that be fair to consider? If it's in effect a corporate death penalty, that's excessive? And I gave you an extreme example on purpose.
Of course. And I guess, we've argued that there's other protections. I mean, we've conceded that you would have a substantive due process claim, so you could raise it. Ability to pay, again, I think it's firmly within the legislature's authority, minus a deprivation of liberty. This court can't write that into the statute, so they didn't. So again, another way to do that is to make the legislature do it, but because I think it's outside of this court's province, absent a deprivation of liberty, it's just not a consideration.
Has the legislature sort of done that here by changing the law since this case?
You mean with adding the settlement provision?
Well, like reducing the statute of limitations period, et cetera? Am I mistaken about that?
I'm not sure if there being a statute of limitation challenge. I mean, I'll
Or
look.
just, like either some sort of cap or at least some sort of period after which you can no longer go after.
I'll look. I'm not aware. I thought that the statutory change I'm aware of is the change allowing the director authority to reduce below the minimum after the fine has been imposed. I'm not aware of there being a cap.
Okay.
And if I'm wrong, then I apologize, but I'm not aware of there being a cap.
Well, then taking at least that particular change into account, like some flexibility or discretion on behalf of the director to reduce the fine, does that suggest ability to pay is in fact now being taken into account?
No, if anything, by placing it at the back end after the fine has been imposed, it just further shows that it shouldn't be considered when the fine is imposed. Because they set the factors for when the fine should be imposed, and they didn't. To the extent ability to pay is incorporated within that change, by putting it after the fine has been imposed, then again, I think it just further confirms that they didn't want it considered when the fine is being imposed. So turning just very quickly to how this test would work, in this case, assuming Solemn applies, and then Lucero would apply in this case, and we look at each fine individually. So whether or not each day of violation is disproportional to a $250 or $500 fine, there's really no argument here that that wouldn't be proportional. I mean, obviously, when you think about the possible risks that could happen daily, $250 or even $500 fine daily for noncompliance, that's not constitutionally disproportionate, and there's really been no argument made to the court that it would be.
But why would we look at daily? Why isn't this just one or at best two fines? I mean, we're talking about an $841,000 fine. I mean, that's very different than saying just look at $250 a day.
Yeah, well, I think it necessarily, as a matter of law and fact, is each day. If you take away any one day, the fine goes down. I mean, there's no dispute about that. And then we also have to look at what the whole purpose of the fine was, and it's each day creates the potential for new injury. So it is a different fine every day.
So then there has to be notice every single day and an opportunity to be heard every single day? That doesn't make sense.
Well, that's a due process question. I guess one that this court denied cert on. And again, as a court of appeals, I do think they did get it correct. It just requires notice and opportunity to be heard. You did have that here. They waived it, so I think this makes this case a particularly improper vehicle. In addition, factually, and I think it bears emphasis, that in this case, there is more than multiple notice. Dami was a subsequent violator. There was the violation in 2006. There's two more notices that, if this court looks in the record, which I think are important, and the director found, I think he was absolutely right about that goes to militate against any finding of a due process issue. And that's the two times that the policies were canceled under law 844-110, the insurance provider is required to provide notice of cancellation. And in this case, if you look on page 58 of the record, there is, in fact, Dami's policies were canceled both times. Once for failure to pay the premium and once for failure to abide by the conditions. So not only do we have notice as a subsequent violator, Dami also received notice twice that the policies were being canceled. So I'm saying to the extent there's any issues regarding whether or not the statute should provide more notice, one, it's outside the cert question. Two, that would be a facial challenge, which again is also outside the cert question. And three, this is the wrong case to do it in because Dami had more than notice once.
I'm sorry to ask you so many questions, Mr. Leah. Thanks for hanging in. So one question just procedurally. Let's say we agree, we go this way and we agree with you, Bahagajan is the right test. Could we rule on the record we have now, or do we need to do a remand, since the Court of Appeals went off in its own direction with the Gore factors?
It can weigh the factors itself. I think it's, as both sides have agreed, it's de novo review. And under those factors, certainly the fines are proportional. I think the correct test is you look at the corporation, not at Ms. Pock individually, in determining whether or not, when you look at the conduct. I just think that's just how the Eighth Amendment works. So that would be the correct application of the test. You look at the conduct individually, we prevail under the abbreviated proportionality review because it's not proportionally excessive. If it goes to extended individually, then we look to see whether or not they could have, within the state, as we pointed out, it would have applied equally in the amount of days based on the agency rule. So there's absolute proportionality on that. If you look at whether or not the fine could have been higher in other jurisdictions, as we pointed out, it could have been in 7. Arizona, Alabama, Alaska, Delaware, Michigan, Oklahoma, and New Jersey. If you look at the fine individually at Ms. Pock, rather than the corporation as a whole, which I don't think is the right test, and I think this is important because I think a lot of the Court of Appeals and respondents' arguments kind of built on this idea of the framing of the case that Ms. Pock reasonably acted and it seems unjust to impose this fine. And I'd say procedurally and factually, I think the record strongly refutes that. Procedurally, Court of Appeals called it uncontroverted that she reasonably relied on her insurance agent. It's not uncontroverted when you waive the opportunity to present the evidence. So it's certainly, she shouldn't have got the benefit of that waiver.
So should we, let's say we disagree with the Court of Appeals opinion, could we remand it for that hearing that I agree it looks like she may have waived it, but maybe that would be an appropriate thing to have happen?
I think after she waived it, you could remand it, I think, for the legal findings based on the record that we have, but because, again, we're reviewing other opinions based by the panel and the director, I think you are limited by the record because she waived the right to present evidence. But even assuming this court looks at the evidence that it has, I think the biggest problem with this case is their own statements controvert their supposed uncontroverted account. And I guess their whole claim is based on this idea that based on Ms. Pock, this being her second language, she was forced to rely on an insurance agent, Mr. Kim, who he admitted that it was his fault in not getting insurance because he just didn't do it, and she reasonably believed that he did. The record refutes that at every turn. If you look at the record on page 104, that's the first letter filed by Ms. Pock, it shows a strong command and an ability to understand legal terms. It's a typed document to the extent it looks like that maybe it was written by someone else. If you look at page 109, there's a handwritten legal waiver of confidentiality written by Ms. Pock to one of her agents, telling her to discuss it with one of the investigators. Again, that completely refutes the claim that she didn't understand legal terms. The second piece is even more important, that Mr. Kim admitted that it was his fault not getting an insurance. If you look at page 113 of the record, that's the note from Mr. Kim. He doesn't say she told him to buy it and he didn't. He says he thinks he has some responsibility because she misunderstood that he should have had it. That's made worse by the fact that if you look at the 5th paragraph of page 104 in Ms. Pock's original letter, she originally says that it wasn't Mr. Kim who bought the insurance, that she had relied on other agents and Mr. Kim was her new agent and he was going to make sure it didn't happen again. So, I mean, that statement's twice impeached. And then as far as reasonable reliance, as I pointed out, that's completely refuted by the fact that she was a subsequent violator and she received notice twice that her policy was canceled. It's never reasonable to rely that your insurance is continuing when you didn't follow the terms and conditions of your insurance.
Is there any evidence in the record as to when the department learned that the insurance had lapsed again?
I think when the investigation started. There's no definitive finding, but I think that's that's fairly borne out by when the documents that they have. And that's normally how it works in the proceedings, is once they learn, then they're required by statute to do the proceeding. So I think under law, we can presume that they learned about it when they filed the action.
In terms of the Bachakajan test, you know, I read that case and I read Gore and Cooper Industries. There are some similarities between the two tests. I mean, they're not completely different tests. What do you see as the main difference between those two tests? Because both of them consider the seriousness of the offense or the seriousness of the conduct. Both of them seem to consider harm that may have been caused. And then you agree that we should compare the fine to fines imposed in other jurisdictions or within this jurisdiction, right?
Yeah, you look at two differences, and I'll try to save a little time for rebuttal. One is expressly under the Eighth Amendment test, we look at each fine with each violation. I think it's implicit in Gore you would the same, but it's expressed with the Eighth Amendment. And I guess I will reserve my last 20 seconds for rebuttal if I may. Thank you.
Respondents?
May it please the court, Paige Orgel on behalf of Respondent Dami Hospitality, LLC. Petitioner imposed a fine of $840,000 on my client Dami when it unknowingly lapsed in workers' compensation insurance. This fine violates the excessive fines clause of the Eighth Amendment. The Eighth Amendment was intended as a restraint on the government's prosecutorial power, and it was drafted to prohibit the government from imposing excessive fines. This is a prohibition on the government regardless of whether the fine is directed at an individual or a corporation, and we know this for two reasons. First, from reading the plain language of the amendment, and also from a review of the United States Supreme Court's analysis when it has extended other constitutional protections to corporations. The Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This phrasing is an absolute prohibition on certain types of governmental conduct. The rule is that the government may not impose excessive fines. The plain language of the clause encompasses all fines, not just fines imposed on certain categories of persons. And we should not now create an exception that would allow the government to impose an excessive fine against an entity because the action is directed at a corporation and not an individual. Now, while the Supreme Court has not ruled on whether the excessive fines clause applies to corporations, it has consistently held that constitutional protections do not vanish just because the prohibited conduct is directed at a corporation. The court has extended certain protections of the First, Fourth, Fifth, Sixth, and Seventh Amendments to corporations. In each of these extensions, the court focused on the constitutional right being safeguarded and not the identity of whom was being protected, and has held that the identity of the actor is not decisive in determining whether constitutional protections apply. The same reasoning applies to the matter at hand. In Dami's case, the issue is that the protection against the imposition of an excessive fine has been violated. The focus must be on the act, that the government committed a constitutional violation by imposing an excessive fine.
Well, please, go ahead. If I might interrupt and just ask for you to respond to your opponent's argument that in those other cases, applying various amendments to corporations, they all boil down to a question of framers' intent and not merely the plain language of the amendments themselves. What's your response to that? And what framers' intent would you point to here to suggest that the excessive fines clause applies to corporations?
Your Honor, I believe that the framers did intend the excessive fines clause to apply to corporations. When the excessive fines clause was enacted, it was enacted as a constraint on the government's ability to extract payments and impose improper fines, either to jail individuals or to effectively put them out of business. When you look at that, what the focus is on is it was meant as a restraint on the government, not so much as a protection for the individual people. I would also like to add that I don't believe that there's one test that we use to determine whether a constitutional protection applies to a corporation. As the United States Supreme Court has extended certain constitutional protections to corporations, it's examined each case and each amendment individually. One thing that we do look at is we look at the framer's intent. In that instance, I believe that weighs in favor of Dami. And then we also look at, in this case, the right being safeguarded.
And is there historical evidence that you would point to support the framers' intent?
Well, if we look at the excessive fines clause, it has roots in English law. So as petitioner mentioned, it was enacted to control the Stuart kings, so the bad Stuart kings, and how they would use fines as a way to effectively beat citizens into submission. So when I look at that, when I read that, I read it as it was enacted in order to control the Stuart kings, to control the government, not as a protection on the individual people.
What about the fact that the rest of the Eighth Amendment is clearly directed to protection of individuals in the context of criminal conduct? And that, as Mr. Lee pointed out, up to now, at least, the Supreme Court, in considering excessive fines cases, has only considered cases that have had some connection to criminal conduct.
Your Honor, I believe the first clause, the excessive bail clause, logically does not apply to corporations. The third clause, the cruel and unusual punishments inflicted clause, logically cannot apply to corporations as well. Unlike the second clause, so the excessive fines clause, which applies equally to both individuals as well as corporations. So logically, it applies equally. And we know from the Supreme Court in Hale v. Hinkle that corporations have constitutional protections that are appropriate to such body. So we have to consider whether the constitutional protection is appropriate to a corporate body. In this case, the first and the third clauses logically cannot apply to a corporate body, unlike the second clause, which logically does apply.
But if we're thinking about the Eighth Amendment as a whole, and let me just say it, I mean, there are other constitutional provisions that would protect corporations against excessive fines, right? I mean, there are due process claims that could be brought. But here, if we're looking at the Eighth Amendment as a whole and trying to figure out what the framers were trying to do with it, why wouldn't the excessive fines clause sitting in between these two clearly individual-related, criminal conduct-related provisions suggest that the excessive fines clause also should be read in that context? That's what the framers were doing.
Your Honor, because I believe that if you just look at the plain language of the second clause, it doesn't in any way limit the kind of fine. It doesn't limit a criminal fine or jail, as we talked about, or any criminal penalties. So how I see it is that the framers intended all fines. Fines can be civil or criminal.
While you're talking about this, can I ask you to address the same question I asked of Mr. Lee? What do we make of the fact that the U.S. Supreme Court has granted cert on the question of whether the Eighth Amendment applies to the states at all?
The Timms v. Indiana case, Your Honor?
The recent cert grant?
Yeah.
Yes.
Yes, Your Honor. So I do agree with petitioner when he says that outcome will have some effect, or may potentially have some effect on this case. However, I disagree because I believe that the framers intended the Eighth Amendment to apply to the states via the 14th Amendment, largely for the same reasons why the Eighth Amendment applies to corporations, or the excessive fine clause applies to corporations, which is that the framers intended the excessive fines clause to be fundamental to the rights of people. And so they would have intended it to apply not only to the federal government, but to states, and for purposes of our argument, for individuals as well as corporations.
Just follow up on that. So basically the selective incorporation problem stems from the 14th Amendment, right? And the due process clause. If the rationale for finding that the first clause, the bails, and the last clause, the cruel and unusual punishment, is something fundamental as a result of it applying to individuals, where does that leave the question whether there is something similarly fundamental about the middle clause if it applies to corporations rather than individuals?
Your Honor, I believe that the second clause, when the framers, or what the framers' intent was that it applied to all citizens regardless of whether they were individuals or if they were individuals who would choose or who chose to associate as a corporation. So when the Eighth Amendment was enacted, I don't believe that they were looking at these clauses in such a limited scope. I believe that they were thinking very broadly, and then when we choose to apply the specific clauses to individuals or corporations, that's where we use the language of Hale v. Hinkle, which we only apply amendments and specific clauses to corporations that can logically apply.
I take that answer to be sort of backhandedly to say you don't think the selective incorporation of the first or third clauses had anything to do with their fundamental nature as affecting individuals.
Your Honor, I don't believe so. So we can also look at the issue of closely held corporations. In closely held corporations, adverse actions against a corporation have virtually the same impact on the individual or the few individuals who comprise the corporation. So in Bureau v. Hobby Lobby, the U.S. Supreme Court held that a corporation is simply a form of organization used by human beings to achieve desired ends. When rights are extended to corporations, the purpose is to protect the rights of these people. So allowing the government to excessively fine corporations, like a closely held corporation in Dami's case, will allow constitutional infringement not only against a corporation, but it has a direct impact on the individual who comprises the corporation, and it effectively strips the individual of that constitutional protection just because they chose to associate as a corporation.
Can I move you to the next question? If we were to decide that the excessive fines clause applies to corporations, why then wouldn't we adopt the excessive fines test? Why would we instead adopt a test that was developed for an entirely other amendment?
Your Honor, so the Court of Appeals applied the Gore factors to the fine imposed on Dami. The Gore-Cooper test has been incorporated by Colorado courts via the Associated Business Products test, and it examines the excessiveness of civil fines and penalties. So because of our court's history of applying the Gore-Cooper test to assess the proportionality of fines, like the fine imposed on Dami.
But not our court's history.
The
Not
Court of
this
Appeals.
court's history.
The Court of Appeals.
So
Yes.
why wouldn't we adopt the excessive fines test?
Well, I believe that right now in Colorado, the Gore-Cooper test is the test that we've used. If we do adopt the Baja-Kajan test, I wouldn't have an issue with that because I think that the result is still going to be the same.
Well, let me focus in on that because I'd like to hear, I'm interested in this too. I mean, the due process cases and the punitive damages cases seem to me to turn on the fact that there's no limit on the jury, and that's kind of a problem. I am aware that the Eighth Circuit and I think the First Circuit have said those cases don't apply when there's a statutory damages provision in copyright law. So here, I'm not sure that the test would necessarily come out the same. If we relied on these due process cases, I mean, one response could be, well, the legislature set forth what the fines are, the end. We don't have an issue of a jury or an agency going uninhibited. So help me with that.
Of course. I would disagree. I think that there is a similar problem with having a fine like this and also allowing juries to have kind of a wide discretion in imposing a punitive fine. And that, I think, is illustrated in this case because, as we've already discussed, there's no cap, there's no limitation on how many days can be fined. So in this case, you have a fine that spans 8 years. And when you have a fine that spans that amount of time, then you start getting into the territory of we're getting a very, very large penalty. There is a lot of, I wouldn't necessarily call it discretion, but there's nothing to stop the fine. You know, there's no cap, there's no limit. So effectively, you can
The fine can stop if the law is complied with, right?
Correct. Yeah, Your Honor, the fine can stop, but as in this case, Dami did not receive notice from the division for 8 years. So if the division provides notice to an employer after 1 week, then that fine is going to be completely different than if the division waits 8 years to give notice to an employer.
Could you address your opponent's argument around his point that the focus should be on the individual fine, the day-by-day fine? There's a violation each and every day that this insurance isn't in effect. And so what we should be looking at is whether a daily penalty of $250 or $500 is disproportionate to that offense, or that conduct, rather.
Yes, Your Honor, in this case, there is one fine. There are not 1,600 something separate fines. Dami received one notice, it received one opportunity for a hearing, and it received one fine. The $250 to a $500 a day fine is guidance on how the fine should be calculated. It's not a mandate that a fine should be imposed each and every day. And if we allow this kind of logic from the petitioner, what it allows the government to do is begin to start imposing small enough incremental fines that it can make wholesale avoidance of the Eighth Amendment. So turning to the actual fine, I want to start with the issue of whether or not Dami's conduct showed an indifference to or a reckless disregard to the health and safety of others. So Dami is owned and operated by Mrs. Soon Pak. Mrs. Pak is a Korean immigrant who is not proficient in English. And due to this language barrier, she trusts and relies on third parties to assist her with running her business. When she began running her business after she moved to America, she trusted and relied on her husband. Her husband passed away, and then she trusted and she relied on her brother-in-law. Her brother-in-law eventually passed away as well. And so then she started relying more on third parties. In this instance, she relied on the insurance agent, Mr. Kim from Farmers Insurance. She instructed him to obtain and maintain all of her necessary business coverage. Now, this business coverage included workers' compensation insurance. He made representations to her that she was completely insured, and she did not receive notice of this lapse until many, many years later with when she received the director's notice of noncompliance. So
It really feels like you're making due process arguments. If the issue is notice, that the fact that she didn't get notice for a long time, first, I think it's her obligation to comply with the law, not the director's obligation to ensure she's complying with the law. But in assessing the size of the fine, why is the fact that she didn't get notice relevant in an Eighth Amendment context?
Your Honor, I believe that it's relevant in our consideration. So when we look at the factors to assess the excessiveness of a fine, it allows us to really dig into the specific facts of the case. And the fact that she didn't receive notice goes to the reprehensibility and the culpability of her behavior. So a situation where she had received notice and she ignored it, and then a couple months later she received notice again and she again ignored it, that repeated behavior, I think, gives us a different outcome than in this case where she did not receive notice.
But in this case, in 2006, she violated the law and failed to have workers' comp insurance. She was fined, so she knew, she was definitely on notice of the law. And then almost immediately after she was fined, she once again fell out of compliance with the law. And then apparently went back into compliance with the law and then fell out of compliance with the law. So she did know what the law was.
Correct, Your Honor, she did. And she, after the first lapse in 2006, that's when she went to Mr. Kim, her insurance agent, and she instructed him to obtain the insurance coverage. And he told her that he would do that and that he did do that.
So this is an example of why I see the test as arguably different. You're addressing reprehensibility, which is a Gore factor. If we were to adopt the Eighth Amendment test and be looking at gross disproportionality, does the reprehensibility fit into that? Is that the same question? I'm not so sure that it is.
I believe that it does because I pronounce it Bajakajan.
Okay.
Bajakajan looks at the nature of the harm and the nature of the offense. Bajakajan does not mandate specific criteria that we have to analyze when we assess the proportionality of a fine. It really lets us tailor what we're going to examine to the specific facts of the case. And
But where does reprehensibility, I'm sorry to cut you off, I know your time is limited here, but where does the reprehensibility fit in? Bahagajan, if that's how you pronounce it, the focus was it was a reporting violation and there was no illegal conduct there. In this case, and so the court says it's not a grave offense because it's just a reporting violation. And then they looked at the other factors. Here, I'm just not sure how even if it was a mistake on your client's part, how that fits into the gravity of the offense. It seems like a different question. As Justice Hart said, it seems like a due process question as opposed to an Eighth Amendment question.
Your Honor, because I believe that when we look at the gross disproportionality, what we want to look at is the nature of the offense. And the nature encompasses a lot of things. And it encompasses what I believe would be what was going on in the defendant's mind when everything was happening.
But why? I'm just pushing back on you, of course. But why? Why isn't the nature of the offense limited to your client left a whole bunch of employees at risk because there was no insurance if somebody got hurt? Isn't that the assessment of whether this was grave or not?
Your Honor, I don't believe so, because I believe that with Bajakajan, the ultimate goal is that we want to have a proportional fine to the crime. So we want the fine to fit the crime. And I believe that when we want to make sure that we're having the most proportional fine that we can, we need to look at what the defendant knew and didn't know. So, which is why a case where it was a pure mistake on behalf of a defendant.
The legislature has set this up as a strict liability sort of situation, right? It doesn't say if you intentionally fail to have workers' comp insurance, you'll be fined a certain amount. It says if you fail to have it, you'll be fined a certain amount. So why does it matter why she failed to have it?
Because I believe that goes to the nature of the offense. I think that when you are creating a fine that is meant to punish a defendant or a small organization in this case, you want that punishment to fit the crime. So you don't want to punish a small, single-member LLC who honestly thought that she was insured. She wasn't knowingly putting her employees at risk as if she did know that she was uninsured and she just chose not to get workers' compensation insurance.
But Mr. Lee, sorry.
Go ahead.
Mr. Lee indicated that I think your client received notice from the insurance company that insurance coverage had lapsed.
Correct. Yes, so she had received notice in the past, and this is where the importance of her language barrier becomes very important. Because when she receives that notice, what she did is she then called her insurance agent and asked, what is this? And
how do we know that? Is that I feel one of the things that makes this case complicated is because of her failure to request a hearing, we really have no factual record at all. She says that that's what she did, but what do we have to rely on to make that determination, if it's relevant?
Your Honor, so she submitted to, at the very, very beginning, back in 2014, she submitted to the division her affidavit and then the affidavit from Mr. Kim, who was her insurance agent as of 2005. And when it first all began, of course, hindsight is 2020. I don't think that she imagined that this would ever come to sitting in front of you all today. In her mind, she was thinking, this is a simple mistake. I can get this cleared up. Let me let them know that this was all just a misunderstanding and we'll be okay. So she sent those items in to the division, and I don't believe the division ever argued against them. And so that inquiry just ended at that point. And no hearing was requested. Again, we get back to, she believed that this was a simple mistake that was going to be taken care of within a matter of months. she didn't think that she did anything wrong and that she could work something out. And again, like I said, hindsight is 20/20. I'm sure she would have taken different measures back in 2014, but that's what she did at that time, not being a native English speaker and just trying to take care of this issue while she continued to run her business.
So I guess I have a bit of concern if let's say we adopt this Eighth Amendment analysis. I'm trying to think how it would have to apply to any Eighth Amendment case. Take the more traditional case where it's a defendant who's challenging his or her sentence on a drug crime or an assault. I can't think of a case where we ever had a discussion as to whether they really didn't mean it or was innocent intent or was a mistake. We look at the gravity and seriousness of the crime. And so I'm still having trouble in this rubric, if we were to say it applies to a corporation, it applies here, how we could put as a factor the innocence of the mistake, because I could see then that a defendant is going to show up in a criminal case and say, it was a mistake, I didn't mean to assault her, or whatever. You see what I'm saying? I mean, so I'm having trouble figuring out how it applies. I mean, we've got to have one test for the Eighth Amendment, I think, not different tests for this context. So perhaps you can help me understand still how we would get to look at her conduct even in determining the gravity of the offense.
Of course. So with the Bajaj-Kajan test, if we're going to go off of that test, what I believe that allows us to do is, like I said, to narrowly tailor the test to the facts at issue and the specific statute or crime that the defendant has committed. In some cases, if you have a criminal activity which is very, very different from this case, then the defendant's state of mind just isn't applicable. However, if it's applicable in this case, then if our ultimate goal is to reach the proportionality, then I think that we do have to consider that, because I believe that helps to assist the court with knowing the seriousness of the offense that was committed.
Would you agree that the Bajaj-Kajan test does not, at least in that case, sort of admit of an ability to pay prong? And are you nevertheless advocating that be sort of tacked on to a Bajaj-Kajan test, and if so, why?
Yes, Your Honor. I believe that the ability for a defendant to pay a fine should be considered. Bajaj-Kajan does not actually say that the ability of a defendant to pay a fine should not be considered. Our Court of Appeals Court in People v. Malone actually considered this issue and noted that the Bajaj-Kajan court noted that the defendant's ability to pay a fine had never been argued. So they left the issue inconclusive. So I think that when we impose criminal fines, we always consider a defendant's ability to pay. And when we consider a defendant's ability to pay, what we're getting at is the heart of the excessive fines clause, which is that we should not financially ruin an individual or a corporation just because of, in this case, a mere accident, when the nature of the offense does not warrant it.
Should we consider the amount of money that she would have paid during the uncovered period? I mean, we're talking about proportionality between the punishment and the offense, right, the conduct. And we certainly don't want to give people an incentive to avoid paying for insurance because the fine later might be less than what they would have paid. So should that be something that we consider?
Your Honor, I believe that that's certainly fair to consider the amount of insurance premiums that she would have paid had she been insured when calculating the amount of the fine.
And do we know, is there information in the record in this case, how much she would have paid if she had complied with the law?
I do not believe that that's found anywhere in the record.
And while we're talking about the record, were we to go this direction, just hypothetically, same question I asked Mr. Lee, do we need to remand? I confess, with great respect to my former colleagues on the Court of Appeals, the opinion felt a little fact-findy to me. And I'm just wondering if we were to say the Eighth Amendment test, Bajaj-Kajan and other cases is the test, do we need to remand and say reconsider in light of those factors?
Your Honor, I believe that would be appropriate.
Thank you.
And unless this court has any further questions, respondent respectfully requests that this court affirm. Thank you.
Thank you. All right, Mr. Lee, get ready.
Constitutional interpretation is based on actual evidence, not guesswork. Regardless of what test this court applies, you're always looking at baselines and ceilings. I think it's important to point out that the baseline isn't zero. The minimum fine is $424,500. The maximum would have been higher plus cease and desist. You look at it individually, but even if you look at it cumulatively, the one thing that I think they really had going for them was that number from the fiscal statement. I'm out of time. Can I finish my thought?
Please.
Was that the $28,500 fiscal statement was the suspected average fine that the General Assembly anticipated to get from the statute. If you think about it another way, even that flips in our favor because that subsumes even under the minimum fine of only 100 days of noncompliance. So the issue is someone like Dami who has 1698, where they should be close to the maximum, or the minimum would be 100 days, should be closer to the maximum. We'd ask you to reverse. Thank you.
Thank you. Thank both counsel. Appreciate your arguments. The case will stand submitted, and we'll be in recess until 1:30, I believe.